Hi everyone listening in. My name is Ivan Kawa, Citizen's Voice, and of course, I am coming today to break down and make brief the Supreme Court ruling on trying civilians in the military courts. But always remember to like, share, subscribe, follow me so that we can do much more content like this and keep you updated. So, on the 31st January 2025, the Supreme Court, presided over by the Chief Justice Alfonse Owiny-Dollo and a panel of 7 judges, delivered a landmark ruling on the trial of civilians in military courts. The case in question here is the Attorney General versus Michael Kabaziguruka, which was decided in favor of Kabaziguruka. Kabaziguruka is the former member of parliament for Nakawa, who had been arrested and charged with offenses related to security and intent to overthrow the government of the Republic of Uganda. We all know the attempt to overthrow the government of Uganda, that is treason, straight away. And treason is charged in the military court, especially if you are also using things that are a monopoly of security like guns and so forth. Now, Kabaziguruka challenged this trial in the General Court Martial, arguing that the court martial had no jurisdiction over civilians. And of course, the people behind all these, the lawyers, you have Elias Lukwago, Caleb Alaka, well known for standing in for some of the high-profile cases in Uganda, and of course the legislator Honorable Medad Lubega Segona. Those were the people behind this petition challenging the trial of civilians in the military courts. Now, the long-awaited ruling took about 4 years, and this decision has been made. However, the Chief Justice clarified that it is not 4 years, giving quite a number of reasons that really happened, but he said it was only delayed by 8 months. But of course, now that is not the most important. The most important was what is being delivered. Is justice going to be delivered? What is going to happen next? Are we going to still witness what we've seen before, arresting people and taking them to the military courts? This is what we're going to find out here. The panel of judges included Justice Monica Karyejira, Justice Elizabeth Musoke, Justice Catherine Bamgemerere, formerly chaired the tribunal of Elias Lukwago. If you remember, when Lukwago was in the hot seat answering questions here and there, he was facing Lady Justice Catherine Bamgemerere. Bamgemerere is also known as an Iron Lady who was before the Land Commission. She made people drink water, my friend. But of course, there was also Justice Mike Chibita. He is the former Director of Public Prosecutions. Then Justice Pasen Knight Tuhaise and Justice Faith Monda. Justice Faith Monda, in absentia, the Chief Justice delivered her judgment. Now, what are some of the key highlights we can get from this ruling? The Chief Justice surprisingly had a 200-page, should I call it a book, that he was having in their hands, and was worried that it may take about 16 hours to read that book. But of course, he condensed it into 35-page summary for clarity and efficiency. But these are some of the things that took part in the ruling. So the ruling suggests that the General Court Martial is unconstitutional for trying civilians. The Supreme Court ruled that the General Court Martial is inconsistent with the 1995 Constitution and cannot try civilians. The composition of the General Court Martial lacks legal expertise, as its members are appointed by the High Command and may not have professional legal training. Of course, this looked at the argument that to be a member of the General Court Martial, it is not a legal requirement, just like you would require a lawyer to study law, then you go through, some processes until you become a judge or something like that. This one lacked in the General Court Martial. It was apparently not there. Now, the composition of the General Court Martial lacks expertise, that one, where the members are appointed by the High Command and may not have professional legal training. That was critical. Then the military tribunals as well were handling capital cases which involve life imprisonment and even death penalties. Yet, the staffs or the individuals have no legal qualifications, and this was raising a lot of concerns. And the Chief Justice was giving in therein examples that, for example, if he as a judge went to the borders of Congo, for example, and is given a gun to protect the country, does it mean he's now a soldier? He said no, it doesn't make you one. So from that analysis, it showed that he was disagreeing that the people who did not study the law to get the qualifications therein to practice law cannot be in good position to administer or lay fairness and fair justice to those who are supposed to get it. Now, the ruling also looked at the independence and the impartiality of the General Court Martial, where it was found that military courts lack the independence and impartiality required for fair justice. And the argument here was that even if fairness is maintained, it is only the Supreme Court that was to determine whether trying civilians in the military court is constitutional or not, which apparently the Supreme Court made a declaration that the General Court Martial was unconstitutional. It also suggested that a restriction of military trials to exceptional cases, and in this aspect, the military trials should be limited to cases where it is unavoidable and where no other courts can handle them. But of course, if now the General Court Martial does not have the competence, technically it means it can't handle any form of case. However, the Chief Justice argued if the amendments are made, then absolutely, if a matter is supposed to go before the General Court Martial or military courts, there should be reasons beyond any form of proof that indeed this offense is supposed to be tried in the military courts, not any other competent court. The state should prove that trying a civilian in a military court is the only option available. That is the only circumstance where the Chief Justice argued that the military courts can have exceptional grounds, but upon proving to them that it is the only way to try someone in the military court, then the immediate transfer of civilian cases to civil courts is, I think this is what each one was waiting for, and I believe all those who are in military courts now should be smiling. Now, the Chief Justice ordered that the ongoing or pending trials of civilians in military courts must cease immediately and be transferred to ordinary courts with the appropriate jurisdictions. So tactfully meaning that whoever has been under trial in the military courts with immediate effect at the time the Chief Justice gave the order must be released. This is what that means. However, he mentioned that the judgment will not have a retrospective effect, meaning it will not overturn past convictions except where a case is still in the courts of law or under appeal. Now, whoever is listening or watching this, that if you committed an offense and the General Court Martial convicted you, for example, me who is talking to you, Ivan Kawa, the General Court Martial already ruled that I am guilty of an offense. So this overturning that the General Court Martial is null and void and is inconsistent with the 1995 Constitution does not as well affect me. It means I will continue serving my sentence wherever I was, put. So that's what it means. Now, the ruling had recommendations, of course. After ruling the illegalities, the inconsistencies, the lack of competent officers, here are the proposals that the Supreme Court made. They made a proposal that civilians should be appointed to serve in the military courts to improve legal competence and oversight. Proposes the amendment of the Constitution to establish military courts that are competent and aligned with the legal standards, because currently the General Court Martial does not fit in the hierarchy of the judiciary. So meaning it cannot be a subordinate court in nature. It operates as an independent, and it seems, in the view of it, it was operating more of as an executive wing of justice. The proposals included allowing the High Court to sit as a court martial in specific cases. And to me, as a person as well, I think this is a very nice proposal, that under circumstances that you have someone who is going to be charged for treason, the High Court can constitute a member court to deal with that offense using the laws of Uganda, meaning anyone who is convicted, you can as well appeal to the Supreme Court. But this has not been the case with the General Court Martial. Now, the ruling also proposed that ensure that appeals for military courts can be heard in ordinary courts, granting military personnel the right to appeal in recognized courts of law. Wow, it was indeed a very, very lengthy ruling, but what we know now, the application, the appeal was annulled, and the Supreme Court pronounced itself on the matter clearly, that all people must be released and the military courts have no powers or jurisdictions to try civilians. Now, conclusively, this ruling, by the way, enters the books of Uganda as one of the things people have been yearning for. Many people have been arrested, crying for all the time being tried under the military rule, where others believed that there was no window for justice, there was no window for a fair hearing. What was decided by the General Court Martial was decided. But what is clear from the ruling is the General Court Martial's constitution was intended to discipline military officers. However, should we wait when they amend the constitution? How long will it take? For now, at least we can operate knowing that the General Court Martial does not exist. Ivan Kawa reports. Thank you for listening in and watching. Subscribe, like, share, so that we keep, interacting and having more of such stories. I sign out.